On behalf of the Center for Human Rights Studies, of which I am not a part, I welcome you to the conference on sexual harassment law and policies in Indian universities, challenges, practices, and perspectives. And what a lot of you might already know is that this conference arises out of a longer project that Rohini and Alia have been involved in, and I'll leave it to them to give you a sense of what that project is and why this conference. But let me start off by requesting Professor Sudarshan to offer his welcome address, and then I'll hand it over to Alia and Rohini.
Thank you, Aushik. I'm actually very happy to have been asked to say some words of welcome, although I see no particular qualification amongst all the others in the university that I might do that. It could be that the Vice Chancellor, who normally and properly ought to welcome guests in our university, particularly those who come from other places, is not here, and he's in Bombay. And so it may be that someone in the sort of system, one of the deans might as well do to start this conference off. There could be another reason, which is that I chair the research committee that makes research grants from within the university. The university is very generous about its research grants, and we were very pleased to support this project that Alia and Rohini submitted, which is to look across the country at how various systems and institutions have been put in place to tackle sexual harassment in the workplace. There's another reason why I'm very happy, because in a way I see this. Many years ago I worked in the Ford Foundation in the Delhi office, and one of the things I did there, which when you look back after you work for some 30 odd years, on what are the sorts of things that you've done that you are happy about. One of the things I'm happy about is that I organized a colloquium in Bangalore for the good reason that it's my hometown, with support from the Ford Foundation, on domestic application of international human rights norms. So I did this in collaboration with the Commonwealth Secretariat in London and with Interrights, which was a body that had just been started to familiarize British lawyers about European law and the European Convention on Human Rights. And we had this conference just convened by Justice Bhagwati, who was then the Chief Justice, and we had Michael Kirby come as a resource person, as well as some others, and Chief Justices of the courts in the region around. And this was a kind of a two-day event where we discussed, what provoked it was that the United Nations has a number of treaties and conventions to which states are parties, but generally the assumption has been on the part of courts that these are international norms, and they cannot be directly applied in their judgments. They have to look at what lawyers call domestic law, the municipal law. And so this conference culminated in drawing up a set of principles called the Bangalore Principles on domestic application of international human rights norms. Now, there were some fallouts after this conference. One was the Chief Justice of Pakistan declared that President Zia's decree that no political party should contest politics because all political parties were, antithetical to Islamic virtue. That was struck down and he cited a number of international, including the International Convention on Civil and Political Liberties, arguing that political parties are a sine qua non of parliamentary democracy. The same thing was attempted by Chief Justice of Malaysia, who who said Mahathir's election as the leader of his party was unconstitutional because he did not follow the party constitution in the election. It was simply assumed that Mahathir has got to be the leader. And so this Chief Justice struck down his claim to being Prime Minister by virtue of being the leader of the majority party and promptly got impeached. But down the line, some years later, we got Vishaka, which is, so I'm happy because, at some point, there's a kind of osmosis and these things take time. But in the end, the Bangalore principles and the wonderful work that Michael Kirby and, the other person who contributed a lot to this was Ruth Bader Ginsburg, who was at that time a federal court judge. So I'm very happy that we got the Vishaka judgment. Also, it was in a case that had really nothing to do with sexual harassment in the workplace, even though the court set out guidelines, because Banwari, the woman who had been raped because she was working in the Rajasthan Women's Development Project, which really was, so what happened to her had nothing to do with workplace, but nonetheless it provided a trigger and a basis for the court to produce these guidelines, after which of course we got legislation and the Act on Sexual Harassment. The UGC produced a report on Saksham and all of these things. But the important point here is really that that we cannot separate this from what happens in the rest of the world, and international human rights norms are very important as a lens, even though we may not get our own legislation strictly aligned to what may have been agreed upon in the UN conference in Beijing on women gender equality. Our legislation falls gravely short of many of the norms to which India is a party as a signatory, but there's work to be done. So I really welcome, I welcome all of you, of course, on behalf of the Vice Chancellor, the university, and so on. But I'm also really welcome that this event is happening here. And I've often wondered, with all the, somebody remarked to me that of all the sorts of universities, that this is an American professor who he has seen in India, the one where there's least political engagement and ferment on the part of the students is the Jindal Global University. We have a colleague called Ramin Jahanbeglu, who's created a group called the Agora. Because Agora, of course, refers to the location in Greece where Socrates held forth, engaged in being the gadfly and corrupting the morals of youth. And nothing like that, happens in a very vibrant way. And I hope this conference and this meeting will trigger some of it, because there was a student of this university who graduated in law, Raya Sarkar, who created a major flutter by drawing up a list of people who she said she had evidence had harassed students or women, and this of course created, but there's been no discussion in this university. Shiv Vishwanathan wrote a piece, some of you may have seen it in Outlook, called something of the chilly wind of Gulam, because he felt that just this kind of setting out a list of names and publicizing it was wrong, and it is like the nomenclatura of the Soviet Union, where people were drawn up as enemies of the state. That's the sort of comparison. So Shiv can be very eloquent and beautiful in his language. He can get carried away by adjectives. Nonetheless, he did try to make the point that in a kind of nostalgic way, what has happened to good relationships between men and women, old-fashioned love and the ability to talk things through as equals and so on. And so he got immediately castigated as an old Brahmin who's not yet got out of his agraharam and is unable to see the world beyond it and what young people are thinking now, and that it's all very well to talk about these poetic things of poignancy and romance, when actually many places are very cruel and hostile to women right now. And so we have had this. I mean, all this is there in the public domain. So here we have Shiv taking a standpoint. There was Raya Sarkar who did what she did. And we've not had any great debate within the university, even though these two individuals one is in the university. So I'm saying that therefore there needs to be a need to stir up, because I think there is a greater worry that people may come into a university like this and say, okay, they're going to get good jobs and get highly paid or whatever, or even think that because they pay more fees than in other universities, they are entitled to the degree and then to a placement, because this is simply so these are attitudes, unfortunately, that are prevalent, and missing in this is that universities and education is all about the kinds of persons that we become, not that we remember what we learn in lectures and classes. It is the sort of person you end up becoming after a process of education. And I think we want a certain kind of person to evolve, and all of these focus on this particular problem of sexual harassment is in fact part of that education as to figuring out what kind of persons do we want to be. And there's another reason why this discussion is important here in this university, because there is I think people would agree that there is a preponderance and an overwhelming dominance of the law faculty in this university. I have a small school called Public Policy with a handful of students, vastly cross-subsidized by the law school, which is the cash cow for the institution. But the problem then is that if people begin to think only like lawyers, it's a problem. It's all right to practice law and to think like law, but law is a language. It's a kind of a language, and it's very limiting in what it permits and what it doesn't permit. So if you take a very legalistic attitude to what should be the composition of your committee that investigates, and what are the standards of evidence, and what will pass muster in court, all of this is important as law. But I think this issue is rather more social, and it mustn't be distorted by the language of law. That's my humble submission. We need to see where law has a place, and why the standards of law, everybody is presumed innocent until they are proven guilty and so on. But we also got to understand that what does it mean to have a grievance, and what does it mean when grievances are translated into complaints, and what does it mean when they are translated into complaints with a legal connotation. So all of these factors do come in, and I think we need a little more clarity about understanding this, and to really at the end of it, make the learning process in an institution a safe and a happy one, not full of tensions and anxieties. I mean, that's what one's aiming at. But there are a whole lot of issues that have to be confronted, sadly, because they are ugly. And I think there needs to be much more debate. There needs to be far more groups. Agora is the one I mentioned that but we need many more groups of students and faculty, and conversations between the administrative staff and faculty, conversations with all the women who are doing the gardening in this university, and our students and our faculty. We did a small survey in the Public Policy School on what places do these people who come from the neighboring villages and find employment on the university campus, what do they think are safe places or unsafe places in this vicinity? Their village, university, that walk from the village to the university and so on. And astonishingly, all of the men thought this is a silly question. I mean, what's the point of this question? Every place is safe, and we come and go every day. Nothing is unsafe. And all the women said, no place is safe, not even our homes, right? Now, if you got this divergence in response to a simple, very amateurish survey done by a set of students, it makes you think that there's been absolutely no conversation between those men and their wives about what they feel about their work environment and whether they feel safe or unsafe. So we won't know until we learn how to converse and talk to one another. We won't know what is going on. And so I think we need much more ferment in this university. So I'm grateful to Rohini and Alia to have started us off. That's what I most welcome, because among all of us, we need more groups, more forums in which we discuss this issue, and this is a very good start. So welcome to all of you. Thank you.
Thanks, Sudarshan. Over to Alia and Rohini to introduce the project and the conference.
Very good morning to everyone. We will not take up much of your time. A quick introduction to the project. As you know, the conference is a part of a longer project that Alia and I have considered undertaking. We are looking at various higher education institutions and the presence of sexual harassment committees there, the invisible barriers, how they function and how they don't, and we hope to share our findings with you in the form of a comprehensive report sometime later this year. The conference is designed to reflect some of the concerns we've had or some of the hypotheses we've had as part of our research. So without much ado, we'll just move straight to the panel then. Over to you.
Great. Okay, so our first panel is themed Changing Social Perceptions in Scope of Sexual Harassment, and open discussion follows all the panel descriptions. And we have 4 speakers, one of whom I think will join via Skype if the connection works well. We have Rukmini Sen from Ambedkar University, Delhi, Saptarshi Mandal from JGLS, and Nivedita Menon from JNU. Because we're already running late, I'm not going to read out the bios of all the speakers. You can Google them. Their whereabouts are all available online. So I don't know whether you want to follow the order that's in. Okay, so Rukmini goes first, followed by Saptarshi, and then Nivi, and each speaker has about 15 to 20 minutes. If you want to end sooner, that's completely fine. I'll alert you at the 15-minute mark and when time's up.
Thank you, Ishik. Thank you, Rohini and Alia. Good morning, everyone. It's wonderful to be here. This paper that I discussed today, I think is building up from some of the previous thoughts that I've tried to articulate first in an essay in The Wire, and then in EPW Engage. A separate issue of mine, but also the one that Geeta Chadha from the University of Bombay and myself co-edited. And I think I'm still building up on the thoughts. And so this is titled Sexual Harassment, Sexually Transgressive, Law and Its Beyond. And intends to map a political-legal history of sexual harassment in India, the engagement with sexual harassment which dates back to the Vishaka judgment, which was a very different moment in contrast to the 2013 moment, and the need to go back to the feminist campaigns on sexual harassment to understand the promises and the limits of the current moment. So I call the first section 1997 to 2013, From Hostility to Criminality. A gang rape of a lower caste woman employee during work hours multiple protests by women's groups across the country, writ petition filed by an organization in the Supreme Court, and the subsequent judgment, Vishaka versus State of Rajasthan, citing UN CEDAW and the fundamental rights of the Indian Constitution, defined sexual harassment for women at the workplace for the first time legally. Bhavri Devi had confided to two of her co-workers about the anyay, injustice, meted out to her. Kanchan Mathur, in a 1992 EPW piece, had written, and I quote, "It is noteworthy that in common parlance, rape is usually referred to as anyay or burakam, rather than as balatkar," unquote. This is actually an important issue for consideration as to how women talk about rape or other forms of sexual violence to their trusted ones. The vocabulary may be limited. There could be a taboo or unfamiliarity with certain words. And in this case, apparently balatkar could have been the taboo word. However, what does it mean when a woman says that she has been wronged? Or what are the ways in which she may be wronged? The wrong here is much more disconcerting to confront than how it can be righted. Not going into the details of the Bhavri Devi gang rape case history, it is necessary to remember that the Supreme Court judgment subsequently led to the imagination of a university-specific prevention and grievance redressal body at Jawaharlal Nehru University, the first election being held in 1999. I constantly bring it back to the higher education institutions because that is where we all are. In other higher educational institutions in Delhi, the DU Apex Committee was formed in 2007. In IGNOU, it was 2008, Jamia 2011, National Law University, Delhi 2014. These dates at the moment, and I'm leaving it at that, but probably later on some discussion around when our committees made and what prompts committees to be made might be important. Post-1997 and pre-2013, the definition of sexual harassment that guided functioning of anti-sexual harassment committees in higher educational institutions is: sexual harassment includes unwelcome sexually determined behavior, whether directly or by implication, as A, physical contact and advances, B, a demand or request for sexual favors, C, sexually colored remarks, D, showing pornography, E, any other unwelcome physical, verbal, non-verbal conduct of sexual nature. Using Article 14, 15, 19, 1G, 21, and Articles 11 and 24 of UN CEDAW, the Vishaka judgment stated that such conduct can be humiliating and may constitute a health and safety problem. It is discriminatory when the woman has reasonable grounds to believe that her objection would disadvantage her in connection with her employment, including recruiting or promotion, or when it creates a hostile working environment. Effective complaint procedures and remedies, including compensation, should be provided, is what the judgment had stated. In 2013, a specific legislation, the Sexual Harassment of Women at the Workplace Prevention, Prohibition, Redressal Act 2013, enacted by the Parliament, which brought the domestic worker, also within the limit of the legislative protection, had the same definition of sexual harassment as the 1997 one. This moment in law reform is the post-2012 Delhi gang rape movement, initiated again by widespread protests across the country by groups of organizations upholding women's rights, sexuality rights, disability rights, and child rights. Among the duties of the employer, as noted in the Act, providing workplace safety and to treat sexual harassment as misconduct under service rules came through the legislation. While at the same time, punishment for false or malicious complaints and false evidence finds a place in this legislation. The fears, conscious campaigns, pronouncements and judgments around misuse of 498A, Protection of Women from Domestic Violence Act, rape laws, seem to have a connection to section 14.1, which is the false and malicious complaint clause in the 2013 Act. It is time to reflect whether there can be a feminist conceptualization around false. And is there a difference in approaching false when it is violence inside the home, as opposed to when it is sexual violation at the workplace. A simultaneous process that occurred in 2013 is the inclusion of Section 354A into the Indian Penal Code. Sexual harassment and punishment for sexual harassment, which has again the same definition of sexual harassment as the 2013 Act, but which comes under Section 354, which is assault or criminal force to woman with intent to outrage her modesty. 354 was the criminal law provision which in fact guided eve-teasing, the popular avatar before sexual harassment became socially acceptable, not just as a legal term, but as a commonsensical term. There have been multiple critical writings against using eve-teasing or even the colonial legacies in outraging the modesty. There needs to be more direct jurisprudential conversations around this legal shift that we were given in 2013, a separate legislation and 354A of the IPC. The two legal homes of sexual harassment, therefore, are rape and outraging of modesty. And I think that it is in this over-criminalization that lie the impossibility to make legal sense or satisfaction in the juridical, hence the need to move beyond the law. The second section I've titled Committees, Commitment, Consciousness Raising. In this section, I briefly reflect on the title of this section through my association as a part of a team towards the framing of the anti-sexual harassment policy at Ambedkar University, Delhi, where I'm teaching since 2011, and being part of a committee against sexual harassment inquiry committees before the ICC directive of the UGC at another university in Delhi. AUD had a gender issues committee since its inception in 2008, in which I was a co-opted member from 2012. Members of this committee anchored the process to discuss the need for a formal institutional structure against sexual harassment in the lines of the JNU GS Cash to deal with sensitization, prevention and redressal of sexual harassment. It undertook widespread consultations with members who had served in JNU and DU committees, lawyers who would assist in the formulation of these rules read through existing policies across universities. Our task was to look at these policies, take the best from them, try and retain the guiding principles of the Act 2013 because the Act has been passed, without compromising on the ideology of the Vishaka judgment. Through a number of iterative processes involving faculty, students, external experts, members of the Academic Council of the University, the Board of Management of AUD in April 2014 adopted the policy which is called Policy on Prevention, Prohibition, Redressal of Sexual Harassment and Discrimination on the basis of gender identity and sexual orientation. After nearly 2 years of discussions within the university, two consistent concerns that came while these discussions were happening at various levels of the university authority bodies were: one, false malicious cases and what would be safeguards against them; two, the power, if one can even say that, of the recommendations made by the Committee for the Prevention of Sexual Harassment should never be in contravention with or a challenge to statutes that govern the functioning of the university. The perceived threat, danger, that even recommendatory committees like these can create in higher educational institutions was evident in the process of these iterations, yet one can't underline the importance of these dialogues to express in multiple ways the commitment towards a feminist praxis on campus, also through the establishment of this committee. It is still an entirely elected body, this committee, with representations from faculty, students, non-teaching staff, hostel residents, research scholars, external members, from a panel of 10 experts. It can invite members from the University Clinic for Psychotherapeutic Services, the AHSAS, if necessary. There were at least 3 important shifts, I would think, in 2014 marking the AUD policy. 1, bringing sexual orientation within the policy as a probable basis of sexual harassment. 2, making any person belonging to any gender lodge a complaint on sexual harassment. And 3, integrating counseling and therapy within the structure. Being part of forming a policy and being part of an inquiry on complaints of sexual harassment are allied but not similar exercises. Feminist critiques of the misogyny and masculinity of the law itself, the legal processes, that one had previously engaged with through Carol Smart, Catherine Bartlett, Ratna Kapoor, or Nivedita Menon, fell in place after my first experience of conducting an inquiry in 2014. How are questions asked? What is the nature of questions? How to ensure that the inquiry process is non-hostile, empathetic, with all the members part of the inquiry with varied views of feminism, campus politics, teacher-student relationships, student-student intimacies. How long does one carry on the process of inquiry, even within the stipulated duration of completion of an inquiry? What are the nature of details that fall within accepted feminist sensibilities? What is the nature of the question to the witnesses? And finally, how is the report written? Is there a space for any ambivalence at any of these stages, or are we talking only of legal certainties? Clearly, the formation of committees like CPSH are not an end in itself. Rather, it is also the beginning of another journey, sustaining an environment of dialogue rather than disciplining, enabling rather than constraining, preventive and not punitive, transparent with anonymity and not secretive with procedural delays. Committees like these are a product of years of women's movements, feminist pedagogies and practices within and outside the university spaces. While reflecting on the gaps between policies and practices, I understood who occupies these crucial committees are of immense significance to an institution. And yet, who can be persuaded to be part of these committees? It's a different matter altogether that through an ICC it is a nominated committee, which I'm not getting into in this paper at least, which requires tremendous amount of time and emotional energy and puts faculty members at awkwardness in workplaces, since one does not stop working with a colleague against whom a complaint may have been lodged. Post-2013, post-UGC guidelines 2015, ICCs are now mandatory within higher educational institutions. And I don't have the time to get into the troubles of that process of making it mandatory itself. But is there a commitment that any such committee cannot merely be a UGC-mandated, authority-nominated team that erases the history through which these came into being? After all, distinctions have to be made between anti-sexual harassment committees and anti-ragging committees within higher educational institutions. That commitment to a cause and presence of cash-like committees, together with women's development cells, women's studies centers, queer collectives, concerns on women, gender, sexuality, masculinities, being part of curriculum in social science, Suction Report, liberal arts spaces, each of these independent histories of taking shape within higher educational have been taking shape within higher educational institutions. And that is not within the purview of what I have left to speak about. Have definitely led to different forms of feminist consciousness among a new millennial student population that inherit HEIs today. It is in this backdrop that the current moment of engaging with sexual harassment as existing in HEIs, even before the FB list or #MeToo, across university campuses since 2014 Ho Cholera protests at Jadavpur University, Kolkata, collective articulations on sexual harassment in campuses were strongly being made by students across university campuses in different parts of the country. It is important to underline that in this changed environment of how does one defy culture of silence, all cash-like committees need to be sensitive towards a more responsive commitment to understand and discuss sexual infringements while encouraging greater dialogue among and between students. University as a space still gives the first taste of freedom and dissent of various kinds to many of its students. With its autonomy, collective articulation of azadi, comes a commitment towards a just feminist consciousness as a political project within HEIs. Hence the need to move beyond the committee. I'll just take another 3 minutes for the last...
You have 3.5.
Okay. For this last long section called Speech and Not to Speak. And in this section, I'm aiming to engage with speech which may or may not be an act of speaking. And I kind of go back, think around Chuppi Toro as one of the constant slogans in posters, in campaigns, in marches, that the women's movement has constantly talked about. I use, and I will not be quoting at length here, but Gita's Undoing Impunity, Speech After Sexual Violence, and Sara Ahmed's A Complaint biography as I engage with the complex questions around what it is to talk, what it is to articulate, and how does one articulate. So what I'm trying to think is that are there spaces in campuses of higher educational institutions to have conversations on the ordinariness of sexual transgressions. And I'm underlying the need to craft cultures of conversations, moving beyond complaints cultures. It is not merely training and legal awareness on the provisions of laws of sexual harassment, but a democratic space being able to acknowledge the complex life worlds that various actors inhabit in an institution of higher learning in contemporary times, which would enable conversations on the possibilities of sexual experiences and transgressions within these spaces. I'm not in any way suggesting that these conversations have not happened in the past and can easily transpire now, even between students, since the diversity and hierarchy of locations that students themselves occupy obscure the possibilities sometimes of these conversations. Moreover, to create democratically enabling spaces for multiloques to happen between faculty and students are difficult, yet not impossible. At least there are urgent needs to do so. Can classroom be a common experience that students may want to converse about? Or can experiences of being supervised, not in the classroom, but in the various sites from the faculty office to the bar, be another common chord among research scholars, since it is a more interpersonal encounter with the faculty? Or is it that there are so many ruptures and layers of access to power and intimacy with power that these conversations will necessarily be about disagreements? But disagreements and differences may still constitute a relational prism, an alliance, a camaraderie, or a solidarity of sorts with the impossibilities of harmony. An unquestioned faith in the complaint evidence committee mechanism is not the only method of doing feminist politics. Caring, listening, conversing, is as much a practice in politics to be reclaimed at this juncture, where there seems to be emergent fissures. Thus the need to go beyond speech as is understood in the law. Thank you.
You're just 7 seconds over. Thank you, Rupali. Over to Shoptush.
Hello, good morning everyone. I'll talk about social perceptions about sexual harassment, especially in the context of same-sex situations. But before that, I want to make 2 general comments about sexual harassment, the framework of sexual harassment law as it has developed, and then think about how it's inconsistent or it fails to capture some of the issues that arise in the same-sex situations. Good? Yeah. So one of the ideas that we are familiar with in all anti-sexual harassment campaigns is desexualization of the workplace. Since women end up becoming objects, being viewed as sexual objects, that's one of the things that duty holders usually do. So employers or in educational institutions, you would see posters or messages asking people to respect women and not indulge in sexual conversations without seeking the consent of the other person, and so on and so forth. So desexualization of the workplace or desexualization of any space is one of the objectives of anti-sexual harassment policy and also law. Some duty holders take it to a different level altogether. So in one of the neighboring universities, there was a poster which said, hey, I like your shirt, sexy. And that was sort of projected as a sexually harassing comment that people should desist from. And so that's one idea. The second idea is of a certain sexual conduct, or certain conduct being unwelcome. If it is unwelcome, then that's the standard that sexual harassment has happened. In the early years, we had a reasonable man standard. So whether a certain conduct is unwelcome or not would be assessed from a reasonable man standard. So if a woman quote-unquote dressed provocatively, flirted with a co-worker or a superior, then judges would usually find that it wasn't unwelcome. It was through conduct and through dress and so on and so forth. There was a suggestion that it was that kind of sexual attention or sexual interaction was actually being welcomed. From there, I think 90s onwards, in a number of jurisdictions, we moved to a reasonable woman standard. So you ask that question about something being welcome or unwelcome from the point of view of the victim. So in a patriarchal society, is a reasonable woman likely to express consent or welcome sexual attention in that manner? That's what you ask. And if you find that a reasonable woman is not likely to do that, then it is definitely unwelcome sexual conduct and it amounts to sexual harassment, right? And we are kind of working with these two ideas in all our anti-sexual harassment work. My contention is that they don't help us when it comes to dealing with sexual harassment in same-sex situations. It's important to talk about this issue because a lot of universities, say for example ours, Rukmini talked about the AUD policy, there's Ashoka University in our neighbor. They also have a gender-neutral sexual harassment policy. A number of private companies also have gender-neutral sexual harassment policy. So it's important to talk about the mechanics of these ideas in same-sex context. So it's not enough to expand the scope of these policies and make them gender-neutral. We also need to talk about how the inclusion is basically operationalized. And my contention is that the current framework of sexual harassment allows for prejudice to creep into the process. This is based on a very few cases. I was on the committee here for a little more than a year, and we handled some cases, but they were not hard cases. They were fairly easy cases where you could sort of pinpoint whether it was a case of sexual harassment or not. But there are some other cases, two other cases where I happened to assist one of the parties, and these concerns are based on that experience of being associated with these concrete cases, right? Now, what exactly do I mean? A certain conduct which is sexual in nature but not harassing might come across as harassing or might come across as harassment to a homophobic person. So for example, in case of one of my friends who works in a private company, he goes to a gym, so do a lot of his colleagues, and they indulge in a bro talk, like what kind of supplements are you having and what's working for you and what's not, and so on and so forth. And in one such conversation, and these are very intimate conversations where they discuss their body parts and what's working and what muscle lies where and how to activate a muscle and XYZ, right? And in one of these conversations, he happened to state that what he wants is a bubble butt. And that seemed to have created a tense atmosphere where no one else could, the straight colleagues could no longer participate. And so it was seen as that the fact that he sort of made that proclamation was seen as creating an uncomfortable environment for the others, and then they stopped hanging out. And in cases where you're trying to determine whether a conduct amounts to sexual harassment or not, whether a certain utterance amounts to an innuendo, or whether a certain utterance amounts to an unwanted sexual advance or not, is likely to be affected by these prejudices. Let me tell you about a concrete case. Of course, I'm going to hypothesize some of the bits because of confidentiality issues. So this is in a university setting. The person who has committed he was found to have committed an offense. So he's an instructor there, gay, openly gay, sometimes wears makeup, sometimes wears skirts, wears his hair long, and some students are really fond of him, others are not. He's also in the habit of taking pictures all the time, like a lot of us do. He takes pictures of all sorts of things, both inanimate and living objects, and then he posts them on Instagram with a lot of sexy hashtags. And so one day he takes a photograph of a fellow employee who was eating a banana, and then he crops the rest of the image but keeps the focus on the banana, and then posts this on Instagram saying, "Hungry, banana, sex on my mind, give it to me," and similar hashtags. The person who was eating the banana but then who was not in the frame really happened to sort of come to know that a picture has been posted on Instagram. And after waiting for a while, he files a complaint against this person before the university committee. Now, before the committee, the aggrieved person's claim is that he was offended because of two reasons. One, the photograph was taken without his consent, and the hashtags. Give it to me, sex on my mind, banana, hungry all the time, that kind of stuff. He said they made him uncomfortable because they were obscene. The hashtags were obscene. They made them uncomfortable. He was disturbed, and therefore he thought it amounted to sexual harassment. Right? So two issues: non-consent and disgusting or disturbing or obscene hashtags. Right? The defendant maintained that he has been doing this all along. He takes photographs of inanimate objects, and in this particular case, he took care to sort of crop the image so that you couldn't identify the person who was holding the banana, who was eating the banana. Right? So the subject of the photo was the banana and nothing else. Somehow it did not cut ice with the committee. Now the committee insisted on the sexual nature of the whole thing and not just the banana. Second, the committee also talked about the public nature of the post. So the defendant's claim was that this is something that I'm doing on my personal blog, on my Instagram, and I'm not revealing anyone's identity. I don't even know who that person is. The committee was of the opinion that it may be your personal page, but it is still publicly. It can be viewed publicly, so anyone can view that photograph. And what if someone who's known to this person is able to identify the banana eater, right? And therefore you are actually going into the domain of public. You are actually publicly revealing the identity of the banana eater, and it's no longer limited to the banana. And also that the fact that he maintained that he had done nothing wrong, maybe he should have taken consent, but then he did not know who that person was. He was a random person eating a banana and he just happened to take a photo. The committee, and so he maintained that he hadn't committed a wrong, it wasn't sexual harassment, and this is something that it's part of his politics to sexualize everyday objects. The fact that he persisted with that line of argument led the committee to note in their report that there was no sign of remorse. And therefore, it just added to the guilt. So you go around taking photographs and then you use all these dirty hashtags and then you don't show any remorse, right? And I mean, law students in the room, where have we encountered this language? It's so judges use this kind of language while sentencing, right, in death penalty cases, that there is no remorse and therefore there is no mitigating. The case does not involve mitigating circumstance. And of course, there being a Bengali in the committee, he was also told that you must be more cultured in your conduct. It's a very Bengali thing. Trust a Bengali to say that. Anyway, so this definitely is not sexual harassment. Was a line breach? Of course. The consent issue, I mean, there was improper conduct, but does it amount to sexual harassment? It does not. It does not. The second issue, obscene hashtags. Sexual harassment? I don't think so. But the very fact that that was sexual speech which offended someone was taken by the committee to be adequate evidence that it amounted to sexual harassment. Now, I think in this case, where there were two employees and there was this, the situation was between, it involved two employees, it still sort of allows us to sort of decide whether it's sexual harassment or not. I want to pose the question by changing the facts a little. Again, in a educational institution setting, what if the banana eater was a student and the other person was a faculty member? I mean, I also take photographs all the time, not of students, but inanimate objects. What if, but what if I take a photo of someone who I don't know, I have never taught, and then I post it with such hashtags? Would we be able to and if the committee sort of comes up with similar findings, would we be able to justify the findings then? In the teacher context or teacher admin staff context, we are still able to sort of answer this question, but would it change our answer in the teacher student context? Would we imagine that that element of institutional power, one person who's breached the line, holding institutional power over the other, would it lead to a different answer? And are we then? I mean, can we really find in favor of the student then? So what I basically want to point out is our current framework of sexual harassment does not help us identify the harm in same-sex situations, and unless we also incorporate a non-discrimination standard within the standards of reasonable man or reasonable woman, or a neutral framing of the reasonable person standard, it's going to yield results such as these. I think I'll stop there, and I would want to hear from the others, not just the panelists, but from the others participants here on the things that I have had to say. Thanks.
Thanks, Shaptoshi. Well before the 20-minute mark. So, 15 minutes, 49 seconds. Over to Nivi.
Thank you very much for inviting me here, and thank you to Rukmini and Saptarshi for bringing me, in a sense, towards my presentation, because I want to place in the background of my presentation the fact that we don't disagree that sexual harassment is an issue, especially in academic situations. We know that it happens, we broadly know what it is, and Rukmini, by outlining the whole history of sexual harassment committees, has given us a sense of the kinds of ways in which we take this seriously. And Saptarshi has actually now brought up issues which take us, in a way, Saptarshi's presentation takes us forward into rethinking some of the verities, in a sense, that feminists have had, which Rukmini kind of outlined. But what I'm going to do is step back from both of them to show that the kinds of issues Saptarshi raised today are very much part of the sexual harassment debates within queer feminism, and it's not an accident that queer feminism has to raise it, and not what we would have called a women's movement. So it's not an accident that that happens, and I'm just going to, what I'm going to do is I'm going to look at three concepts, or I'm for the moment going to call it concepts as I go along, one or two maybe verbs, I don't know. But three ideas to illustrate what I'm going to say, and at the end of it I do not expect to have given any answers, as indeed our other two panelists have not, and that's not the purpose of this workshop. So let's look at the idea of sexual harassment first of all. That's this thing called sexual harassment. And let us remember, and Rukmini did remind us, that we produced this idea. That is, feminists produced a notion of sexual harassment in order to deal with feminists globally, so this is like, we're talking about 4 or 5 decades ago, globally, where we tried to arrive at a term that would express the range of what feminists saw as violence, which is not physical necessarily, which is not necessarily rape, which is in that sense easier to understand, but a range of behavior that feminists felt was problematic. So the term sexual harassment was produced, the idea of eve-teasing, now no one uses the term eve-teasing anymore, but I've grown up in a world, and maybe even younger generations like Rukmini, and I don't know about Saptarshi, but eve-teasing was fairly commonly used, and now I really don't see it anywhere. I do not see the term eve-teasing anywhere. So what we did was we produced this idea of sexual harassment in order to expose the normalized violence of a range of behavior, which did not amount to physical violence, but which is produced, of course, by heterosexual sexuality in a patriarchal, misogynist society. So we wanted a term, sexual harassment emerged as that term, and we produced through this the idea that violence against women and misogyny is not only physical. So making someone uncomfortable, discomfort, whether it's welcome or unwelcome, etc. These are the ways in which we produce this. Now the flip side of this is that as queer feminists, we had intense discussions even after Vishakha on what it is about making uncomfortable, particularly in the classroom of a queer feminist. What is happening when, as feminists and as queer feminists, we are talking about body parts, we are talking about sexuality, we are saying that gender, a world in which there's a binary gender is a world that has been constructed. You read Anne Fausto Sterling, I'm assuming many of you may have read it, where there are physical descriptions of 5 kinds of bodies, and we are talking about testicles and clitoris and all of this kind of thing. Did it make students uncomfortable? Yes, it bloody well did. That was the point of the class. And we ended up, and I've been teaching for over 30 odd years now, every class, whether it's a class of only women or a class in which they're both men and women, there would be astonishing discussions. There would be hostility, but there would be amazing discussions in which no one said, I don't want to hear you talk about the clitoris, it makes me uncomfortable. Supposing I was talking about periods, that also could have made people uncomfortable. So the idea of discomfort we found very problematic, and we recognized that the first people to be caught under these kinds of discomfort scenarios could well be our kind of teachers. For example, it is not at all a coincidence today that Judith Butler's effigies are being burnt in some extremely conservative Christian countries. I to think janam safal hua. Matlab, if a gang of religious fundamentalist, religious right-wing people burn my effigy, not me, I'm quite happy to be distant from the effigy, I would really think janam safal hua, because clearly there is a huge discomfort that Butler is producing, and all over Europe, where the Christian right-wing is taking over, gender studies, for example, are being banned, and so on. So we can see where this, I mean, you can well imagine a policy in which young people say, I was uncomfortable with the teacher mentioning periods in class, because the classroom is meant to make you uncomfortable in a variety of ways. Now, as feminists, we know what the proper kind of discomfort is and what the improper kind of discomfort is. We know it, you and I know it, we are very clear about it. How do we write that into a policy? So I'm not saying it's impossible to write into a policy. I'm simply saying we have to keep this in mind, that there are forms of behavior which make students uncomfortable, which as a feminist, even as a queer feminist, I can accept as problematic. And there are other forms of making uncomfortable which I would treat as a pedagogical move. So this question is going to hang in midair. How does one translate this into policy? And that's the kind of conversation we need to have. It's not a rhetorical question. We cannot do it. I'm just saying we need to talk about it. How to define it in policy so that it is exclusively feminist. The second idea is of consent. And when it comes to consent, I think I do have a disagreement with Saptarshi that the desexualizing of the workplace is a problem. I might argue, and again, it's not like a well thought out and sort of a saleable argument. I think it might be necessary to desexualize the workplace as a matter of policy, precisely because of the power relations involved, but also because of emotions. Because the fact that, let's say, two people are involved, they're on a committee, then it's assumed, rightly or wrongly, but most probably it is correct to imagine that two people who are in a relationship might speak in one voice in a committee, etc., etc. So is there a way in which we recognize that human relations are inescapably sexual, but you decide that this is not the space where that sexuality should be expressed, particularly in a teacher-student scenario, where, for example, in JNU many years ago, in 2013, we tried, some of us, to produce a code of conduct for supervisor-student relationships, in which we explicitly spelt out that even consensual relationships with a student should be declared, and then that teacher should step aside from any grading, any marking of that, not only that student, but the entire class, because if it's not a supervisory relationship, if it's a class, because the knowledge that your teacher is having an affair with your peer produces a hostile work environment for everybody else. So we complicated consent in the sense that these are obviously and it's almost always men and women, although we do know, for example, very recently of Avital Ronell. I'm assuming you're all familiar with that situation. So is it not better, because obviously Avital Ronell's way of being a teacher was to be sexual, but is it not better to have certain rules about that and say not in the classroom and not as long as someone is your student, or not as long as someone is your employee? Perhaps that it's a kind of very clear a way in which one is placing certain blocks. One recognizes what one is doing and one desexualizes. Now, but so consent between powerful and powerless, I think I would just assume that to be we have to create a space in which such a situation does not arise. And I cannot see how a supervisor-student romance can be acceptable under any circumstances, or a teacher-student. Even if you, because when we raise these questions, sometimes we are told, but what if they get married? Yeah, like seriously, that's supposed to have, so that means you get married at the end of 3 years and all the time you wonder, oh, is that why she got her first date? You know, so I think there's something to be said about desexualizing the classroom. It's a, I'm going to use the word taboo. Perhaps it's necessary, so when you say taboo, you're recognizing it's social, you're recognizing it's a construct, you're doing it deliberately in order to create a space in which something else can happen, other things can happen, etc. Okay. Now, that's where consent between powers is concerned, but when you come to consent between peers, then I think the issues that are arising before us, and especially those of us who've sat in sexual harassment committees and so on, GS Cash in JNU, and I'll come to why GS is important in GS Cash. GS Cash in JNU in the earlier days. So I want to very quickly say that the new law of 2013, which overturned all the sexual harassment committees under the Vishakha guidelines, this new law is so problematic. It really needs to be completely, I would say, maybe not even redone, but we need to think afresh, what they call going back to the drawing board. It is a seriously problematic law. It serves no function whatsoever of either preventing sexual harassment or ensuring justice. So, so that there's an issue with that, but that's not my point here. My point is that when we think about sexual harassment, so I was saying that when there are cases that come of sexual harassment in previously consensual relationships, and often GS Cash has counseled the complainant and closed the case, because we have come to realize over the years that we don't have a way, and when I say we, I consistently mean we as queer feminists, we don't have a way of speaking about all the aspects of a patriarchal, all pervasively patriarchal, misogynist, heterosexist society. We don't have ways of speaking about it. So sexual harassment and an existing law and an existing policy becomes a way of talking about all of that. And it becomes a problem. So consider, for example, this is not about sexual harassment, but consider, for example, the provision in the Indian rape law that if you give consent to sex under a false promise of marriage, that can be treated as rape. That consent can be treated as vitiated by the judge because you gave it under the impression the guy would be marrying you, clearly straight man-woman sex scenario. And often women do go to court, and most often judges basically castigate the complainant, saying you go around sleeping with men and then you expect to be given a rape judgment. But sometimes they accept it. Sometimes judges say, well, you know, a good Indian woman would never sleep with a man unless she thought he was going to marry her, so she has been. So in either case, whether you secure a conviction or don't secure a conviction, it's a highly patriarchal idea that has been re-established. However, think of the woman. It is most probably true that she would not have slept with the man. It is entirely possible that in such scenarios there are women who would not have sex with a man unless they thought they were going to marry him. He has sex with her, then he goes and marries the woman his wife, his parents choose for him, dumps her. Her sense of incredible injustice and frustration and resentment, where is she to go with that? So it's a real issue. But does sexual harassment or rape describe that issue? So I'm using that as an example to say that as people, and especially if you're LGBT in a sort of massively heterosexist environment, or if you're a woman in a patriarchal misogynist environment, there is a whole range of all-pervasive misogyny, heterosexism and patriarchy. How does one talk about it? And are there some other ways in which these conversations can take place? Because sometimes it seems to me increasingly, let's say you consent to a date on Tinder. It's fully consented. And he turns, and this is a woman and a man, and the man turns out to be an entitled, typical man, straight man, and he, the whole event ends in you feeling humiliated because he only thought about his pleasure. Is that sexual harassment? What does one do with that? It's a real issue. What is the name for it? How does one talk about this? So consent raises these kinds of issues. My third and final point has to do with an old feminist debate, but it seems as if all the old feminist debates are like slowly waking up and stretching and saying we were here all along, is about sexuality as desire versus sexuality as violence. And all of us know the Catherine MacKinnon, Carol Vance debate, in which Carol Vance, so this debate was over pornography, and Catherine MacKinnon only talked about pornography as violence, and she in fact defined heterosex as violence, that all heterosex can only be violent. And Carol Vance, who is actually a lesbian woman, MacKinnon at some point did marry a man. I'm just saying that you can't put these things on a very clear, that you can't expect one voice to come from one subject position very clearly. Subject positions are complicated. So Carol Vance in fact said that we need to think about sex as desire rather than sex as violence, and her response to the idea of pornography is that pornography can generate desire for women as well, and the solution is not to ban pornography and so on, which was MacKinnon's solution, but to produce multiple voices about what pornography is. And through this, so for example, if you remember it's not in your time, but you might remember it as a debate, the Choli Ke Piche song, Choli Ke Piche Kya Hai, which was treated as obscene, and and then the song was banned, and Sohini Ghosh people are actually saying, no, I've never heard of it. Oh wow, this is a millennial universe. Guys, go watch it. Choli Ke Piche Kya Hai is a song with Madhuri Dixit and Neena Gupta singing it to each other. There are two versions of this song in the film Khalnayak. One in which the man pursues the woman singing Choli Ke Piche Kya Hai, and there was the court thing said that a lot of men were saying this on the road and harassing women, etc. And then there's another version of the song which is Madhuri Dixit and Neena Gupta singing it to each other, and Sohini pointed out that the version that eventually went was Neena Gupta and Madhuri Dixit singing to each other, and the sexually harassing version of the song remained. So the point here is that if we are to treat women as having sexual agency, then we need to think about sex as agential and therefore as about desire. But I guess the final point I will make here is that when we were discussing, many of us were discussing some of the narratives in which women have clearly been violated. Yes, 1 minute hopefully. In which women have clearly been violated, and there's no disagreement on that. You look at the publicly written articles in Wire and so on. I'm not talking of Me Too at all. I'm talking, which has also had those kinds of, I'm saying women with their names who write an article in the Wire or Scroll saying I was raped, for example. When you look at the steps that lead up to the rape, you feel she took such dangerous steps. She took such huge risks in going with this man. Why did she go with this man? Why did she do that? Or when we hear narratives of date rape, because as faculty in JNU, we are all at some point or the other, and I still am approached by students who want to talk about date rape, and we try to figure out ways in which, so you go to the man's room, you're sitting in his room, you're drinking with him, you have some kind of sexual foreplay, and then you want to stop and he doesn't stop, that kind of scenario. In these kinds of scenarios, when we say why are the women taking these risks, we actually understood one thing, that feminism has won in a way, because there's a whole generation of women which believes quite clearly that this is our right. We can say no, no means no, consent is mine, my body is mine. I can go with this guy and drink, and I can agree to kissing and a little for, making out, and then I want to say no and he should stop, because that's what feminism has taught them. But as the Americans say, the men haven't got the memo. The men haven't got the effing memo. Sorry. Carried away. What a Freudian moment. So I think I'll just conclude by saying that the GS part of the GS cache, therefore, that is gender sensitization and conversations and production of where men are part of it is time's up, he tells me, very meaningful. So I'm with a smiley, I noticed. So I'll just stop here to say that clearly gender sensitization and talking about it is equally important.